what planet does that person with that sexual offense history, with being biologically male and also 6'2", not pose a threat to the safety of female inmates? I don't understand how you could conclude that this person shows no risk of being an offender. Now, you argue at one point that this person has shown no pattern or history of offending while in prison. Yeah, because JJS was in prison with a bunch of other men where the size and strength differentials aren't quite the same. Can you help me understand this?
Thank you, Senator. First, the crimes for which the petitioner was convicted are horrific. I've been a sitting United States magistrate judge for 12 years. Sexual offenses against children are...
And she just directly contradicted her own report. I'm just going to read her own words
just
because
fair,
it's exactly the opposite of what she said. Your own
Senators,
report.
Senators, I gave both of you more time to finish your line of questioning. I allowed the witness to finish her. I allowed the witness to finish her response. I allowed the witness to finish her response. That is,
I understand that you're scared of the facts.
I have
Senator Peter, Madam Chair,
open up
she has an obligation to explain why she directly contradicted what she wrote in her report.
Okay, Judge Netburn, is that right?
Yes, sir.
Tell us about a case you had, I think, involving, get my facts right, the transfer of a person, a female, male who became biological male. Does this ring a bell?
Yes, I know which case you're referring to. It was a habeas petition.
Yeah, and it was somebody who had been convicted in '94 for raping a child and a male child and raping a 17-year-old female. They served their sentence. They got out. They were convicted of distributing child pornography. The biological male transitioned into being a female, and the Bureau of Prisons objected to the person going into the female system. Do you remember all that?
I do, Senator.
Okay. And you basically ruled in favor of the petitioner, saying that the Bureau of Prisons' concerns about the intimidation and the threat to female inmates was theoretical. Is that right?
Thank you, Senator. In that habeas petition, I issued a report and recommendation which was based on the facts that were presented to me. Those facts included statements from the 3 wardens who supervised this petitioner, all 3 of whom recommended that the petitioner be transferred to a women's facility because of her serious medical needs. And the Bureau of Prisons...
The Bureau of Prisons opposed this transfer, right?
Well, the wardens who were directly...
No. The Bureau of Prisons opposed this transfer, right?
Correct, which is why the petitioner brought a habeas petition.
Right. So now I'm over time, but I'll wrap it up. The bottom line here is that the concern of the Bureau of Prisons is that a biological male transitioning to a female with a history of sexual violence would be intimidating and threatening to the female population. You thought that to be a theoretical concern because the person in question had attacked male and female people. Is that right?
That's not correct, sir.
That's what you said.
I based my report and recommendation on the record evidence before me.
So you think the concerns of the Bureau of Prison that someone with a violent past regarding sexual assaults would not be threatening and intimidating a biological male transitioning to female? You just don't believe that's a legitimate concern?
Let me be very clear, sir. The crimes for which the petitioner was convicted of 30 years ago are abhorrent, and the petitioner was convicted by an Indiana state court and sentenced.
Well, she was convicted of assaulting a child, raping a 17-year-old woman, got out of prison, and was convicted of child pornography afterwards, transitioned from a male to a female, and the Bureau of Prisons said, we do not believe this person should be in a female prison, and you thought those concerns were theoretical. Is that fair?
I based my decision on the record before me.
You want to finish your statement?
Thank you, Chair Durbin. I based my decision on the record before me. The record was that the 3 wardens who had supervised the petitioner all recommended transfer. The petitioner had had no disciplinary issues at all during her time in federal custody. She had never engaged in any violence and, in fact, had been the victim of sexual violence while in a male facility. And the Bureau of Prisons' longtime treating medical provider also testified during a 2-day hearing before me, who recommended that the petitioner be transferred because of her serious medical needs. I recommended that the district judge adopt my recommendation based on Estelle versus Gamble and Turner versus Safley. The district judge adopted my report and recommendation, and the government did not move for a stay.
Thank you.
Mr. Chairman, I want to follow up with Judge Netburn regarding the JJS case. I've been reading through your report and recommendation, and I just want to review the fact that this was an individual, JJS, who had raped a 9-year-old boy, raped a 17-year-old girl, was put in prison, went to prison for a long time. After that person was paroled, JJS, the way you put it on page 44 of the report and recommendation was that that JJS sent 2 sexually explicit images of minors in 2015 while out on parole. I should point out this is kind of a euphemistic reference. These were not just sexually explicit images. These were sexually explicit images of adults violently molesting children, sexually assaulting, abusing children violently. Every time this person has had an opportunity to offend, this person has offended. And yet you recommended this person against the recommendation of the U.S. Bureau of Prisons to go to a women's facility. Now, your reasoning here is stunning to me. Going back again to page 44 of your report and recommendation, you say, quote, "There are no signs that petitioner is at risk of reoffending." I'm struggling to understand how you could possibly conclude that, because the minute this person was released, this person engaged in other offenses. Yes, not a contact offense while out on parole, but there are still issues going on. It says nothing. You don't adequately grapple with the obvious fact that this is a 6'2" biological male. Yes, transition aside, the transition didn't begin until age 51 or 52. By then, JJS had acquired all of the physical, biological size and strength advantages of being male. Those don't go away because there is a transition. On what planet does it make sense? On what planet does that person with that sexual offense history, with being biologically male and also 6'2", not pose a threat to the safety of female inmates? I don't understand how you could conclude that this person shows no risk of being an offender. Now, you argue at one point that this person has shown no pattern or history of offending while in prison. Yeah, because JJS was in prison with a bunch of other men where the size and strength differentials aren't quite the same. Can you help me understand this?
Thank you, Senator. First, the crimes for which the petitioner was convicted are horrific. I've been a sitting United States magistrate judge for 12 years. Sexual offenses against children are among the worst crimes that we see. This person was convicted by guilty plea 30 years ago of 2 awful crimes and was sentenced to a very significant prison sentence by the state court judge. About 8 years ago, the petitioner committed another awful crime, the crime of distribution of child pornography. That is an abhorrent crime, and there are real victims. And the petitioner was sentenced by the Indiana federal court.
I understand this. This is all undisputed. What I want to know is, why is it okay? Why is it safe? Why is it fair to female inmates to send this person to a female prison? This is a guy who raped a 17-year-old girl and a 9-year-old boy. Why is that safe? 6'2" biological male.
Senator Lee, as I do in every case before me, I look at the record evidence. I consider the facts before me. In this case, the facts that I considered included that every single warden who supervised this petitioner recommended that the petitioner be transferred to a women's facility because of her serious medical needs, because she had engaged in no violence, no infractions, and in fact had been the victim of sexual assault and
While
harassment.
in a male prison, and this was against the decision of the U.S. Bureau of Prisons. Judge?
Judge Netburn, I was looking at your resume. You went to Brown University, is that right?
I did.
And then you went to law school in California?
That's correct.
And you've worked for the Brennan Center?
I interned. I was a law student intern.
Okay. And you worked for the Center for Reproductive Law and Policy?
I was a law student intern there for 8 weeks during my 1L summer.
Okay. And you are a political activist, aren't you?
I am not. I'm a sitting United States magistrate judge.
Okay. All right. Do you remember an inmate named William McLean, also known as July Justine Shelby?
Yes, I know who you're referring to.
Okay. Mr. McLean raped a child, didn't he?
30 years ago, the petitioner in the habeas case before me,
Did he rape a child?
he pled guilty to that crime. Yes, it's abhorrent.
And then he raped he raped a little boy, right?
I believe that's correct. I believe he pled guilty to 2 acts of sexual violence.
And then he raped a 17-year-old girl, right?
Again, this case was handled by the state court in Indiana, but I
I'm
believe...
just asking you the facts.
I believe...
Don't stall on me now. Did he rape a 17-year-old girl or not after raping a 9-year-old boy?
I believe that's what he pled guilty to.
Okay, and then he went to prison, didn't he?
Yes, the petitioner was...
And then he came out and he sent child porn, basically adults raping little children, to another sex offender. And he was sent back to prison, right?
The petitioner pled guilty to
Was he sent back to prison?
Well, that case was in the federal system, so...
Was he sent back to prison?
Yes, this time to federal prison.
Thank you. And then he decided to transition, and he became a female and started going by July Justine Shelby. Is that right?
Yes.
And Ms. Shelby said, I don't want to go to a male prison. I want to go to a female prison. And the Board of Prisons said, what planet did you parachute in from? You're going to a male prison with this kind of record. And you sent him to a female prison, didn't you? You said that the Board of Prisons was trying to violate Ms. Shelby, former Mr. McLean's constitutional rights, didn't you?
I issued a report and recommendation to the district judge recommending that the district judge transfer the petitioner to a women's facility. The district judge adopted that recommendation.
The Board of Prisons was trying to violate Ms. Shelby's, Mr. McLean's constitutional rights, didn't you?
So I based my decision on the facts that were presented to me in the record
But
evidence.
it wasn't that your ruling?
I recommended finding that under Estelle versus Gamble.
Why won't you admit that was your ruling? Are you ashamed of it today?
I'm not. I'm answering the question. I applied Estelle versus
But
Gamble.
was that your ruling?
My recommendation was that the petitioner's serious medical needs were being denied by keeping her in a men's facility.
A violation of the Eighth Amendment, right?
That's correct.
Okay. And how big was Ms. Shelby, Mr. McLean?
I don't have a specific recollection. Your colleague just suggested that she was
was
more than
6'2"?
6 feet tall.
And you told the Board of Prisons, well, she'll be okay. The other women in the female prison will be okay because it's only hypothetical that Ms. Shelby, Mr. McLean would reoffend again after he's already raped a 9-year-old boy and a 17-year-old girl and has been sending child porn through the mail. You said there's no chance he'll reoffend again. Did you say that?
Senator Kennedy, I based my decision on the record.
But am I
evidence.
right? Did you conclude that?
I don't have a specific recollection of that. I did recommend that after finding a constitutional violation.
What were you thinking in saying it's only hypothetical that she would reoffend?
The facts of the case were that the petitioner had last engaged in a contact offense 30 years ago. The petitioner had not engaged in any contact offense. In addition, the medical evidence made clear that for the last 5 years, the petitioner was sober and hormonally entirely a female, and there was no evidence.
The Board of Prisons didn't agree with you. I'm not going to run out of time here. You're really a political activist, aren't you?
I am not, sir.
But your record demonstrates otherwise.
I disagree. I apply the law to the facts and come to a fair decision. All of my decisions that have been appealed, particularly this one, the district judge adopted my report and recommendation in full, and the government did not move for a stay of the decision.
Well, Judge Netburn, I'm going to continue on this line of questioning. In your court, what matters more, the rights of individuals or your political ideology?
I apply the law to the facts.
I asked a question, which matters more?
Well, my political ideology doesn't matter at all.
Okay, so I don't believe you. And I think this case demonstrates that you are willing to subjugate the rights of individuals to satisfy your political ideology. This case involves a male defendant who raped a 9-year-old boy. Was he guilty of that?
Yes, the petitioner pled guilty to that.
Okay, so he raped a 9-year-old boy. He also raped a 17-year-old girl. Was he guilty of that?
He pled guilty. The petitioner pled guilty to that crime as well.
So was he guilty?
I hope so, because she pled guilty to it.
He was a he when he did this.
That's correct.
And also criminal deviant conduct, which the record doesn't disclose what that was exactly. Then, after serving in prison, Mr. McLean was released for parole, but then violated the terms of parole by having internet and was sent back to prison. 1 year after being released again, he was convicted of having child pornography. Is that correct?
I'm unclear on exactly the time frame that you're at, but the petitioner was convicted of distributing child pornography.
Child pornography that was images of adults violently raping children.
Abhorrent conduct.
Okay.
For which there are real victims.
And this individual, 6'2", biologically a man. A minute ago you said that when this man decided that he was a she, you said this individual was, quote, I wrote it down, sober and entirely a female. That phrase struck me as remarkable. Did this individual have male genitalia?
I think what I said, or at least what
that is a verbatim quote, entirely a female.
Sorry, what I meant to say was hormonally a female.
Okay, but that's not entirely. Did this individual have male genitalia?
Yes.
So you took a 6'2" serial rapist, serial child rapist with male genitalia, and he said, you know, I'd like to be in a women's prison. And your answer was, that sounds great to me. Let me ask you something. The other women in that prison, do they have any rights?
Is that a question you're
yes,
asking me?
The other women in that prison, do they have any rights?
Of course.
Do they have the right not to have a 6'2" man who is a repeat serial rapist put in as their cellmate?
Senator Cruz, I considered the facts presented to me, and I reached a decision based on what the law
I asked you a
is.
question. Do they have a right not to have a 6'2" man who is a serial rapist put in as their cellmate? Do those women have a right to that?
Every person who's incarcerated has the right to be safe in their space.
But you didn't think so. You didn't think so. And in fact, I'm going to give some quotes from your order because Senator Kennedy is right. This is not a judge's order. This is a political activist. By the way, the beginning of your order says, at birth, people are typically assigned a gender. I got to say that would astonish a lot of Americans. A lot of Americans think you go to the hospital, a baby is born, and congratulations, you have a little boy, a little girl. The assigned a gender, I know you went to Brown, but it sounds like it's in a college faculty lounge with no bearing on reality. The Bureau of Prison argued what I'm saying right now, that if you put this person in a female prison, there will be a risk of sexual assault to the women. And you know what you did? You said you didn't care about the women. I'm going to quote what you wrote. You wrote, quote, The Bureau of Prisons claimed penological interest in protecting female prisoners from sexual violence and trauma. This interest is legitimate, that's kind of you to say, but there are no signs that petitioner is at risk of reoffending. The record is devoid of evidence of incidents of violence or assault during petitioner's incarceration when she was the perpetrator, only the victim. A theoretical risk of sexual assault by the prisoner without more cannot support the BOP's position. No evidence, theoretical. Have you dealt, in what universe is someone who is a serial repeat child rapist not at a risk of reoffending?
Senator, as I do in every case.
I know you've been told to repeat the line, I follow the law. I asked a question. In what universe is someone who is a serial repeat child rapist not at risk of reoffending?
Sir, I looked at the facts that were before me in this case. All of the evidence, including the statements of every warden who had supervised this petitioner.
You also wrote, the BOP also posits that permitting petitioner to live among women will be traumatizing and possibly dangerous to them. This concern is overblown. I have to say, if I were the father of one of those women, and you decided that my daughter's cellmate was going to be a 6'2" man who over and over and over again committed violent sexual assault, I would say the entire justice system is absurd, and it is clear on your record your political ideology matters a heck of a lot more than the rights of those women that you endangered. I think you're a radical, and I think you have no business being a judge.
Judge Netburn, there was an opportunity during your exchange with Senator Cruz that you were attempting to offer a response relative to the conditions under which this petitioner was unsafe in the facilities in which she was being held. I'd like to offer you the opportunity to finish that response.
So the facts that were presented to me and what I relied on to make my decision were that the petitioner had engaged in no violence, no physical violence, no acts of sexual violence whatsoever while in custody. All three wardens who supervised the petitioner requested that she be transferred to a women's facility because of her serious medical needs. In addition, the Bureau of Prisons' longtime medical provider testified at a 2-day hearing in my courtroom and recommended that the petitioner be transferred because of her serious medical needs. And the last thing I'll say is that the Transgender Executive Council, which is the body that makes decisions on behalf of transgender transfer requests within the Bureau of Prisons, never said that the petitioner could not be transferred, and never, ever said that she couldn't be transferred because of any risk of violence. What the Transgender Executive Council repeatedly said in denying the request was simply that she needed to maintain her hormone levels. That was the repeated justification for the denial of transfer. But the petitioner had reached full female hormone levels before even being incarcerated. At the time, the district judge in Indiana who sentenced the petitioner requested that she be placed in a women's facility. Her hormones were entirely female at that point, and so the decision by the Transgender Executive Council to deny the transfer request based on this idea that it was only because her hormones needed to be consistent and stabilized, I found was a pretext, but they never once said she cannot be transferred because of violence. It was always based on this idea that our hormones had to be.
Thank you, Judge Netburn. Senator Padilla.
Judge Netburn, that's directly contrary to what your report
you all have
said.
had
That is directly contrary.
No.
We're going to be follow up, and that's how it works.
There is not.
That is exactly how it works.
Look,
if you follow up, you didn't get extra time, and she just directly contradicted her own report. I'm just going to read her own words because it's exactly the opposite of what she said. Your own report.
Senators, I gave both of you more time to finish your line of questioning. I allowed the witness to finish her. I allowed the witness to finish her response. I allowed the witness to finish her response. That is,
I understand that you're scared of the facts.
I have
Senator Padilla, Madam
can't
Chair,
just open
Thank you,
up
Madam Chair.
testimony and then
she
not
has an
give us a
obligation
chance
to explain
cross-examine.
why she directly contradicted what she wrote in her report. She says in her report, the Bureau of Prisons' claimed penological interest is in protecting female prisoners from sexual violence and trauma. She just told you the Bureau of Prisons didn't say there was a concern about sexual violence and trauma. Those are directly contradictory, and why are you contradicting what you wrote in your report?
And what are you
Madam
trying to
Chair, I
hide,
believe
Madam
I have
Chair?
the floor.
No, wait, point of
I
order.
believe
Senator
I
Padilla.
have the
What are you
Senator
floor.
trying to
Padilla.
hide,
Are you going to let her
Madam
answer that question?
Senator
or you
Padilla.
don't want her to answer that question?
Senator
You're
Padilla.
afraid?
This
Very
is
much,
a
Madam
cover-up,
Chair.
Madam
Senator
Chair.
Are you
Padilla.
afraid of the answer to
This
that?
is
Colleague.
no
Cover-up.
Are
Senator
you afraid
Padilla.
of the answer to that question?
Senator
Colleagues,
Padilla.
So yes,
My
you are
time.
afraid of the answer to
This
that
is
question.
Senator Padilla.
Please hold
Clearly,
my
you're
time.
afraid of the answer to that question.
This is
Thank you.
absurd. I have a point of order, Madam Chair.
Yes, Senator Kennedy.
Madam Chair, with respect, you allowed the witness to go at length and to change her testimony without her being subject to cross-examination. Are you going to allow us to have a second round of questioning?
No, Senator Kennedy.
What are you trying to cover up here?
There is no cover-up, and Mr. Padilla, Senator Padilla, you'll be allowed the 30 seconds remaining
I
left
want
of your
to
time.
appeal the ruling of the
Thank
chair.
you. I'd like to hear the
I would
the
like to
responses
appeal.
from the two
Madam
witnesses
Chair, I have a
remaining.
point of order. I'd like to appeal the ruling of the chair. You allowed a
Your
witness-
point of order was offered and responded to,
and I appeal the ruling of the chair and call for a roll call vote. You allowed a witness, let me state my case.
Sure.
With respect. You allowed a witness to go on for 4 or 5 minutes, change her testimony, knowing full well that neither Senator Cruz nor I could cross-examine her about her perjury.
Senator Kennedy, would you allow the witnesses
I'm
to finish
still in
responding
the
to my
middle of a
question,
point of
and
order,
then we can
Mr.
act
Madam
on
Chair.
your request?
And I think we
Senator
should
Kennedy.
have a second round.
Senator Kennedy.
And I am appealing the ruling of the chair.
Senator Kennedy,
Senator-
would you allow the witnesses to finish responding to my question, and
And
then we
I
can
am
respond to
appealing
your request?
the ruling of the chair.
Senator Kennedy, I gave you a response to your request of a second round of questioning. I have no intention on allowing a second round of questioning.
And I'm
There is-
appealing your ruling.
That is fine. There is no procedure that allows
I
for
would
a
ask for a
roll
roll
call.
call
There
vote.
is no procedure for it that allows for a roll call vote in this committee. This is a hearing. I have the gavel. I have
this is
responded
a
to
cover-up,
your
Madam Chair.
request.
This is an
and I am
embarrassing
going to
cover-up.
I
return
will
to
say I've
Senator
never seen
Kennedy's.
a chair try so hard to protect a witness and avoid answering why she just lied on the stand with her own words, her own opinion.
Thank you so much for your request. It has been heard, responded to. Senator Padilla,
not- but
your...
There will be no cross-examination.
If I would like-
The witness shall be
But I
allowed
want
to
to be
lie,
sure I
and no one will ask
understand
her.
your ruling. I think I have the floor.
There, you have,
Your ruling
you have
is-
been,
your
you
ruling
have,
is-
you asked for, was there going to be
Well, I'm
another
raising
round
the
of
second
questions?
point of order. Your
The answer
ruling
is no.
that we can't have a second round, that the chair can allow a witness, after we're finished with cross-examination, go on at length, change her testimony, potentially perjure herself. We're not allowed to cross-examine in a second round of questioning, which we do all the time.
The answer is
And
no,
you tell
Senator
me I
Kennedy.
can't, and you now ask for a roll call vote to appeal your ruling.
Madam
and you
Chair.
say I can't do that.
No, you cannot.
That's
Madam Chair, point of
Thank
personal
you.
privilege, please. Madam Chair, point of order.
Senator Hirono.
You know, we have been witness to literally witness badgering and now badgering of the chair. She has issued her ruling. There is no appeal. Some of us would like to get on with this hearing.
I'm sure you
and
would.
To have to sit here and listen to all of you go off time and time and time again. And I just want to commend this witness, this nominee, for her comportment, because what her comportment says to me is that she is going to be a damn good judge. Can we get on with it, Madam Chair?
So does every Democrat senator want to cover up the facts here? Is any Democrat
So can we
senator interested
return
in the direct
to
contradiction
Senator,
from the
we'll be
witness?
returning to Senator
Apparently,
Padilla's
the entire
questioning, or
Democrat
we will
senators that want to
adjourn
cover these up.
today's
You want
hearing.
to adjourn? Go ahead. You can do that.
Go ahead.
Senator Padilla, I
We
want
might
to give
as
you
well.
your 30
You
seconds.
might
Way
as
you're
well,
gonna run the
because the
hearing.
Padilla, I want
questions
to
are
give
going
you
to
your 30
be, are you
seconds.
more
If you
handsome or
wish, you can
beautiful
yield
or
your
brilliant?
time and we
And
can
let's avoid the
gavel
Madam
facts.
Chair, what I would like is an opportunity for the two remaining witnesses to respond to my question. And I would really like all members of the committee to pay them the respect they deserve and to let them finish. Ms. Newman.
Thank you, Senator. I do agree with the premise of your question. I did have the opportunity to complete 2 clerkships.